So here's something that might surprise you. Did you know that a single wrong digit in a commodity code could cost a UK business thousands in overpaid duties? And most companies don't even realize they're getting it wrong.
Wait, thousands from one wrong number?
Exactly. And that's just the start. Today, we're diving into UK trade compliance, what it actually means, why it matters, and honestly, why so many businesses are getting caught out right now.
Okay, so let's start with the basics. When people say trade compliance, what are we actually talking about?
Right. So, trade compliance is essentially making sure that when you import or export goods, you're following all the rules. That means customs declarations, commodity codes, duty payments, rules of origin, sanction screening. It's a whole framework of regulations, mainly overseen by HMRC in the UK.
And I'm guessing this got a lot more complicated after Brexit.
Massively. Before Brexit, if you were trading with the EU, it was basically frictionless. No customs declarations, no duty calculations, goods just moved. Now, every single shipment to or from the EU needs a full customs declaration. That's millions of additional declarations every year that UK businesses weren't doing before.
So businesses that were only trading with Europe suddenly had to learn a whole new system.
Exactly. And many of them still haven't caught up. They're either making mistakes on declarations, using the wrong commodity codes, or they're paying duties they don't actually owe because they don't understand the reliefs available to them.
Okay, let's talk about commodity codes, because you mentioned those. What are they and why do they matter so much?
So every product that crosses a border gets classified with a commodity code, also called an HS code. It's a numerical code that tells customs exactly what the product is, and the code determines how much duty you pay. Get the code wrong, and you could be overpaying or underpaying. Both are problems.
Underpaying sounds like the bigger problem though, right? That's where HMRC comes knocking.
Absolutely. If HMRC audits you and finds you've been under-declaring, you're looking at back payments, penalties, and potentially even criminal charges in serious cases. But overpaying is surprisingly common too. Businesses just accept the duty rate without checking if there's a relief or preferential rate available.
What kind of reliefs are we talking about?
Things like inward processing relief, where you import materials, process them, and re-export. You can get duty suspended on those imports, or customs warehousing, where goods are stored without paying duty until they're released into the UK market. And then there are the trade agreements. The UK has trade deals with dozens of countries that offer reduced or zero duty rates, but you have to prove the origin of your goods to claim them.
Which brings us to rules of origin. I've heard this is where it gets really tricky.
It is. Rules of origin determine where a product is considered to come from for trade purposes, and it's not always obvious. If you buy fabric from China, sew it into a shirt in Turkey, and then ship it to the UK, where does that shirt originate? The answer depends on the specific rules in the trade agreement, and getting it wrong means you can't claim the preferential duty rate.
Okay, so we've got commodity codes, duty reliefs, rules of origin. What about sanctions? That's been in the news a lot recently.
Huge topic. UK businesses have a legal obligation to screen their trading partners and the goods they're shipping against sanctions lists. That means checking that you're not doing business with sanctioned individuals, companies, or countries, and the lists change constantly. Russia sanctions alone have added hundreds of new entries in the last couple of years.
And if a business gets this wrong?
The penalties are severe. We're talking unlimited fines and up to 10 years imprisonment for sanctions breaches. It's not something you can just hope for the best on. You need a proper screening process.
So what should a business actually do if they're worried they're not compliant? Where do they start?
First step is always a compliance health check. Look at your current processes. Are your commodity codes correct? Are you claiming the right duty rates? Do you have a sanction screening procedure? Are your records in order? A lot of businesses are surprised by what they find. The second step is training. Make sure your team actually understands the rules. And third, consider whether AEO status, that's Authorized Economic Operator, makes sense for your business.
What's the benefit of AEO?
AEO is essentially a trusted trader status. It tells customs authorities that your business has been vetted and your processes are sound. The benefits include faster customs clearance, fewer inspections, and it's mutually recognized with lots of other countries. It's a real competitive advantage, especially for businesses that trade regularly.
So to wrap up, what are the 3 things every UK business trading internationally should be doing right now?
Number 1, check your commodity codes. Get them professionally reviewed if you're not confident. Number 2, make sure you have a sanction screening process in place, even if it's basic. And number 3, invest in training for your team. The rules are complex and they change. Keeping your people up to date is the best protection you've got.
Great advice. For anyone listening who wants help with any of this, Nexus Customs and Legal offer all of these services, from compliance health checks to training courses through the Nexus Academy.
That's right. You can find everything at nexuscustomslegal.com. Thanks for listening, everyone.
Thanks for listening. See you next time.